and then many activity in Professor Ji Park, uh, and then we thought and reported to your time is 30 minutes. Professor Ji Park LLP, time is yours.
Hey, thank you for having me here. It's an honor to be with a student in Diponegoro and also the dean and vice dean of the law faculty. Since I don't have a full name, I just thanks to Tri Laxmari and Dias Dias Mata Angita. Is it correct? uh, Dean and Vice Dean, for inviting me here. I've been in Diponegoro quite a long time ago. I think it's 7 to 8 years ago, and at that time, I don't know her current status. The professor let know was dean, and then dean at the time is now uh, the lecturer of Diponegoro. The time has changed a lot. So much of the the WDU student, including Hafid, lecturer Hafid, was very successful, and at that patch, one prosecutor and Hafid, he is now a lecturer, and two lawyers, and also one is working at the humanitarian ministry in Indonesia. And I'm so happy to meet lecturer Hafid also. If you have a question, you can, I think you can give me a chat if you have a question also. Or we can have a Q&A session later on after having the lecture. Um, okay, so Assalamualaikum. It's quite late though. Okay,
So,
and let me start with the uh, profiling of a personal data. Is my the screen is sharing with everybody? Yeah. So everybody can see my screen, right?
I will check.
Yes. Okay.
Yeah.
Okay. So let me give you the first question here. Okay. The question here is, maybe I should just close it, but it's hard to. Let me just uh, move it a little bit. Okay. 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 Here. Uh, but I like to you to see every question here. Okay. The question number one. Everybody can answer, I think. Okay. Do you think your test answer and the comments made are personal information? So this question was given by the Peter Noah. He here I wrote down all the information regarding this test. So he took a test given by the Institute of Chartered Accountants of Ireland, which is a CAI. This test constitutes of a first and second and third. And first is actually just a general test, and second is three subjects of second accountant test. And there's a one open book test. He he passed first and second subject test, but he failed to the open book test 4 times. After this happened, he applied for the open of the personal information, including the answer he has given to and the comments by the commentator. And his application and request was rejected. Of course, it went to the court. And what happened is that this court asked European Union with of this issue. Okay, let me read the issue. As a written answer by the candidate in a professional examination, Examiners' comment with respect to those answers extends to the data subject's right to access and rectification under EU 1995 Personal Information Directive. So the question asked is whether can I have my answer paper back and the comment given by the comment, right? And what do you think is the result of it, right? So the answer I'll give you from the judgment. The judgment concluded written answers submitted by a candidate in a professional examination and the examiner's comment with respect to those answers are included included to the personal information data. So any comments by the examiners with respect to those answers considered also as personal data. So what you're writing when you're taking your final test is also personal data, and also the comments given by the professor is also the personal data. So you may consider what is going on with your paper at the examination and the comments given by the professor here in Yongsan University, and also all other university in Korea, they supposed to keep every answer paper given by the student for 5 years. It is mandatory for professors to keep the answer sheets, answer papers by the written by the students for 5 years. If you don't have it, you miss it, you get fined. So I keep everything, including KakaoTalk message also, because that also includes some of the information relating to the exam. Then I should keep it. I have to capture it. So why is it? Why is it that the answer given by the student or the applicant who applied for the test, and also the comments given by the examiner, are personal information? That's because of the definition gave by the GDPR in EU, right? So reasoning, let me read it back to you here, although you are sharing the information here. The use of expression any information in the definition of concept of personal data within the Article 2A of the Directive 95/46/46 reflects the aim of the EU legislature to assign a wide scope to that concept. So actually the information is quite wide, but here it says that is intention of the legislature, right? And which is not restricted to the information that is sensitive or private, but potentially encompass all kinds of information, not only objective but also subjective in the form of opinion, assessment, provided that it relates to the data subject. So as regard to the latter condition, it is satisfied where information by the reason of this content, purpose of effect is linked to the particular person. Now, this is important. What is important? The reason of its content and purpose of effect is linked to the person. So, if anybody can notice, identify the person who wrote this paper is Peter Nowak, and the examiner's comment is given to him, if that is identifiable by handwriting style, by the answer style, by the some correct answer and wrong answer, then that is identifiable, then that is personal data according to the definition of 2A of the Personal Information Directive of EU in 1995.
I'm
So this
sorry,
is
Prof.
Yes.
This is not slide not work. This is just page one, page two. Slide is not.
Slide.
Yes,
Can you cannot see?
yes, just page two, not must not next first slide.
Uh, let me. It is now okay.
Okay, Prof. Okay. Yes,
Okay.
it's okay.
Yeah.
Okay, thank you, Prof.
Okay. So here the first question I gave you is the answer paper and the comments by the professor or the comment examiner, right? Since we have done the question number two, I'll give you the question number two. You also answer, okay? So I think you can answer it with your knowledge, current knowledge also. Do you think information you have given to the immigration officer and process information is personal information? So there are two questions in one set. Two question is first, you go to Malaysia or you go Singapore, you go also Korea, you go Japan, United States. You fill out all the information according to the request of the immigration, right? And are those all information is a personal information? That is first question. Among these two questions, um, second question is, and then after the immigration officer has received your information and they analyze where they will accept me or you or us to US or to Malaysia to Singapore to Hong Kong, China, where you would like to go. So that process information is personal information. Here I have given you the answers right away. So if you like to see the full contents of this question and this case number C dash 141 slash 12 in EU, you can find the full script of the this case there. So the name and date of birth, nationality, sex, religion, and language is personal information, of course. Um, for example, you lost your password and your cell phone company requests certain information to give you the new password, right? And then you what they give you the certain information you want to put in. That is basically your gender and also date of birth, including year and month and date, right? And if you put that there and then they give you the new password slot and you put your new password and then you link it again. So that is something that database, the cell phone company database can recognize you. You know how they collect your personal information and how they find you through this gender information and date of birth. That is how they identify you, right? So that link identifiable information is personal information data. However, legal analysis considering all the factors surrounding one person to process during immigration procedure is not information, personal information. So how do they assess you is like a secret. So they are not obliged to open that information to the person who apply for the immigration process. uh, this is the different conclusion from the one set because first question I gave you, they said the personal information is quite wide, right? But second question here is that analysis. that itself is not a personal information here. Okay, so we have to distinguish it. Yeah, let me go to the next page. Yeah, question number three. Okay, question number three here is, do you think daily working hour report is personal information? This is also the case of EU, and this case said here in Spain, they supposed to share working hour information with the Ministry of Labor directly at basically live streaming to check whether the company is controlling the labor condition properly. It is mandatory for the companies in Spain to report working hour report every minute. So then what happened is that this working information was uh, not given to the ministry ASAP. So that became the company got the penalty, and then company asked whether this information is personal information or not. So here it says, since daily working hour is different from person to person, you can recognize individual by checking who worked at what time and who took a break at what time. So therefore, record the working time is personal information. That means the personal information supposed to be encrypted, and that information is supposed to be handled properly according to the EU procedure, right? So here, this case is from 2013, and the company Wharton had filed the information, and then the rule says the principle relating to the data quality and criteria for making data processing legitimate and security process like working time, record working time, accessed by national authority responsible for monitoring working conditions, employer's obligation to make available the record of working time so as to allow the immediate consultation. But this is considered to be personal information. They should handle it well according to the regulation of the GDPR. So I gave you the three questions. Now you might wonder where these all the answers are based on what law. And I was talking to you about GDPR a couple of times. So here it is. The General Data Protection Regulation is called the GDPR, and GDPR is started valid at the time of 2018, May 25th. And I will share the information what's going on with Indonesian GDPR. Uh, it is not still enacted in Indonesia, but it will be soon in a month. So that's a good news because unless Indonesian parliament enacts uh, similar GDPR law, then Facebook will be having fun, not keeping all the regulations as high as the GDPR in Indonesia. Means that it's easy to collect Indonesian private personal information than EU citizens. You don't want to be that easy state. So you want to make that this law as soon as possible. It's a urgent matter actually. So this is a GDPR, and GDPR is consists of usually it was like 34 articles when it was a personal information directive. There are two kinds of rule set in EU. If EU individual nation can have their own regulation that is called directive. Here, I give you back. Here it says regulation, right? The General Data Protection Regulation. Then regulation apply to all EU members equally, and this regulation is supposed to keep by every EU members. And the strictest one is actually England, but now England is not a member of EU. They are out of EU on the processes. But so we might consider a role model of personal information protection is EU and as well as England. Okay, so GDPR has 99 articles and also 173 recitals, meaning recital means lots of comments regarding how you apply this regulation and how it actually has been applied. Also, those comments relating to any confusion on the provision. Okay, so here chapter 1 has a general provisions, chapter 2 has the principles, and chapter 3 is the right of data subject. And let me just give whole uh, outlook. Okay, here chapter 4 has a controller and process, and chapter 5 has a transfer of personal data to third countries or international organizations. This is what the Facebook and Google is facing, and hiring so many people to keep this article 44 to 50, right? Because they cannot transfer personal information data unless they have a proper standard kept in one country. Okay, and chapter 6, independent supervisory authority, and chapter 7 is cooperation and consistency. Chapter 8, remedy liability penalty. Unless company gets penalty, they will not keep it. It's as simple as this. In South Korea, there are so many chemical companies. If we had a low penalty and fine, they will simply just pay and do the bad actions over and over again. So we had made the fines up to twice and 10 times harder. Then now they are on the track of keeping the regulation of a chemical substance. So it is. If Korea has a strict rules, then those companies will move to other countries with the easy regulation. This is very simple. That is what happened to the chemical companies in the world. And that is what happened to the trash companies in the world. China has blocked the plastics since 3 years ago. Uh, then what happened is that plastic cannot go anywhere other than where. So they send the trashes, plastic trashes to Korea. They send the trashes to Hong Kong. They try to now bury all the plastic trashes on their own ground because they cannot send it to the China anymore. Once the country has a strict rules, and the other country are the victim of the easy rules. Okay, so remedy and penalty is very important also. We'll cover that again. Okay, and here let me go to the this is what you have to remember if you are uh, just think about GDPR. This is the summary of a GDPR. Here, Article 3 says much broader territory scope. So means that this GDPR applies to any company handling EU citizen and resident information. So Korean company or Indonesian company handling the information relating to EU citizen, and something like a Korean company is selling ramen, and EU citizen is clicking to see what is that ramen then the EU citizen can link to that Korean company site. Then you have to uh, have a proper security for the person's identity, right? So this is what is a territory. Anything relating to EU citizen and residents has to keep this um, territory scope. And second important, Article 7, this one you have experience, right? When you first have enrolled the Facebook, did you opt in clicking the commercial companies? I like to give my information to certain companies. Or there are also many companies written below. You did you click it? This is opt in. If you click in, they make you to consented to that contract. That is opt in. Opt out is something that you can everything is already consented, and if you don't want to receive those things, you have to opt out, right? That is opt out. It used to be opt out, but no longer. It is now opt in. Explicit consent is required. So stricter requirement regarding explicit consent is necessary according to the Article 7. Article 15 is the right of access. So information on controller and the store the personnel data must be provided. So specifically, what department and what position is handling your information should be given. If information basically says something like a Facebook company, it's, it's not correct. The Facebook company data process uh, department, what position is controlling your data. That is correct response to the your consent. So right of access, you have to know who to call because you have to be able to call or give information you want to be corrected. Then you should have information, contact information. So this is why right of access is important. Also here, right to rectification. If the information is wrong, you have to be able to correct it. Once, the internet is very wide and fast, so information became changed or it is wrong, you should be able to correct it. But someone else already linked it, what am I do? What am I going to do? So that's the teacher's situation. So here it is, right to rectification is important and right to erase. This is something that is also important. If delete the data if it's no longer required for the original purpose. So if your information, maybe you moved your house to another place and you don't want to reveal your previous house, then you may ask the person to delete your information some point. So this is the right to eraser. So like a eraser with a pencil, you should be able to erase your information if that is not correct anymore. Okay. And right to data portability is that once you sometimes you have a membership, right, to certain internet sites, and you are no longer part of the internet site, then you want to be out. Then you may ask, what information regarding me has been used? I want to know. Uh, I want to make sure that my information, my personal information, is no longer used, right? So in that case, you can ask them to copy of all the information provided to third party, and also you ask delete of your information. So this is a portability. Then they may give you the electric file of the data that they have used for 1 year, 1 year of the time. Now Korea has only Korea has a law that you can opt in, but only for a year. Unless you apply for more than a year explicitly, usually consent you give it to the person as a maybe one time or the 1 year. So you may check the right of data portability if you want to out of the certain membership. Okay, so processor notification, DP by design and default. Now, DP by design and by default is also important. I was thinking having open a business in Indonesia, like connecting a university to lectures in some point, and then this data law is going to be enacted in Indonesia. Then I might have to hire so many people handling the personal information. So I was, oh my gosh, this will take a long time to process personal information, because anything related to the personal information is now at the target of the government. So you have to, before you think about your business, you have to think about how to design your business in harmonizing personal information law, right? That is DP by design and by default. And process, notification, data protect officer, and sanction, those things here. This is all summary you need to remember. Okay? If you forget things, just remember these articles. Okay? And now, I have just written down something that is very important, and you may just check what is personal data here with any information. Remember the question number one, the reason why your final exam paper, as well as the answer given, the comment given by the professor, is the personal data, is any information here. Any information. That is the intention of the legislature relating to the identified or identifiable natural person. So anything relating to you, if anybody sees your paper and, oh, this is somebody who I know, paper, then that is identifiable, right? So I'm not sure whether Indonesian GDPR is having this specific definition, uh, because that law is still in the Parliament Senate process. It's not out yet. I hope this broad concept of the personal data is given to you to protect your privacy. Mm. So identifiable natural person is one who can be identified directly or indirectly in particular. This one is something that you have to think about it when you open an account in Google, when you open an account in Facebook or anywhere. Uh, Maybe you use Gojek, and you have to provide also information where you are now and where you are heading to. Those are GPS information also is personal information. Okay, so profiling here is very scary, scary vocabulary actually here. It says concerning the nature person's performance at work, economic situation, health, personal preference, interest, reliability, behavior, location, and movement. So this profiling make it possible to evaluate certain person's aspects relating to the nature person, in particular to analyze, or predict. So here, let me give you an example of Korea. Korea has lots of apartments, and there those apartments have certain names or brand names, like a Diponegoro Law Faculty is a number one in Indonesia, right? As a law faculty, everybody want to be in Diponegoro faculty, as I know. Like that, in Korea, there is a certain apartment they want to be in. The Korean apartments are really high rising and very tall. Even 101 floor of a apartment exists. And if you write your address, they automatically people recognize how rich you are. And if you write down certain area or a certain location of your address, they recognize you are poor, you are rich, you are just in the middle. So that give you the assessment without knowing you, just writing at your looking at your address, they recognize you as a rich person or a poor person. So this is a big dispute in Korea. This profiling make it worse of those misconception and prejudice. So this is something that the society has to solve. Still, profiling is for the analysis and prediction of your habit. So, have you experienced the Facebook having your custom commercial pop up? Maybe you are doing some Facebook chatting, and there is a pop up that you have clicked previously. Maybe you have looked for a dress or the something they nice to wear, and then next thing is you see that commercial again and again. How they got that cookie, because you may have consented previously that you will receive commercial according to your habit of research. Okay, so that is the profiling. Okay, so where this personal information protection came from? So this is the one. The right to privacy is a part of 1950 European Convention on Human Rights. And from this Human Rights Convention, the right to personal information has brightened, right? But however, right to privacy is a explicit one. This right to personal information is not explicit. And they say everyone has the right to respect for his private and family life, his home and correspondence. That is why the European Union was thinking about having a right to personal information, making bigger than right to privacy. Now this issue is so big. Every company they have to have a compliance report before having any business with the relating to EU citizen or residents. This is such a big business impact GDPR has. Okay, so the history of this personal information directive is in 1994, they using personal information directive in EU, they first banned ads, the how the spam mail and spam commercial is bugging you every day. So they banned it through this personal information directive. In 2000, the majority of financial institutions offered online banking. So now it is online banking process. And 2006, uh, Facebook opened. Are you using the online banking system in cell phone? No. They collect your habit of spending, and they also make you notice uh, Monday you bought this a lot, and this is how much you have spent this month, and they compare your spending habit, right? These are all new things by the online banking system in here. Also, the Facebook opened in 2011. A Google user sue the company for scanning her email. You know why Google has scanned her email is collect her habit of information. They are searching for the certain vocabulary, certain terminology, and they wanted to know. And what the goal of this searching is to give target target commercial to her. And then she kind of noticed that the Google is searching her email. Then 2 months later, this EU Data Protection Authority declared the EU need a comprehensive approach on personal data protection. This is how directive became the regulation, because EU now think, because there are so many Facebook, Google, and other LinkedIn, WhatsApp is part of Facebook also, right? So those big companies is to keep searching for targeting consumer or retargeting the consumer. That is why the EU has started this GDPR uh, to be enacted in 2018. At this point, you have to remember that anybody relating to EU citizen, you have to comply with the GDPR. And what's the fine for violation of GDPR? Is very high. I wrote it here. It's there are two options actually. One is 20 million euro. Here I wrote it down, 20 million euro, or 4% of global revenue. So think about how much the Google and Facebook will earn every year, and they pay 4% of them revenue to EU. Huh? They want to? I don't think so. They will comply with the regulation. That is why they are complying it. Here, this I don't even uh, I just kind of changed the check the currency app and wrote it down, but I cannot read. This is too much for Indonesian currency, right? So this is how much in 20 million euro for fine for not complying with the GDPR. Okay, so these informations are important for you to decide whether the personal information you're having and you like to enroll in any of the websites. You have to consider this personal data definition they give you: data processing, data subject, data controller, data processor. Recently, I received the Google new personal data information protection policy. Every time you enroll anywhere, you check it. And even for that, you have to minimize the consent. And also, uh, year limitation is there, so you have to check whether you are consenting it for how long year. That is very important. So data protection principles are also here. There used to be six. Now they have provided Article 5.1 and point 2, 7 principles that the data has to be lawful, fairness, and transparent. So processing must be lawful, right here, and purpose limitation. So data, anything you given to them has to have a certain legitimate purpose, otherwise they cannot use. And third, data minimization. See, I said the schedule of timing of all those, you have to have um, minimize the time frame for them to use. Okay, and accuracy, you must keep personal data accurate, up to date. So if anything is wrong, you can ask them to change it, rectify it, erase, or even you want to just come out of their membership. Okay. Storage limitation, that is also, even if your membership is over, they might keep it. So you have to make sure your information should be deleted at the time of opting out time, right? Integrity, confidentiality, so these are also the principle, and accountability, compliance as everything for them. Okay, and let me ask question again, since I have passed a little bit of time here. Data relating to the applicants for residence permit and legal analysis contained in an administrative document preparatory to the decision. They ask full copy of content. Okay, so let me give you the story. There is a person here, YS. Okay, YS wanted to be the green card holder. You know what is green card? That is a permanent resident. So in US, that they call it green card holder. You can stay there for without voting rights, which is a political right. You can stay there as long as you want. So the person YS wanted to stay in a certain country, so he applied for the immigration, and he got rejected. If he got permitted, he will not ask it, right? Because that's over. But he got rejected. He wanted to know why he got rejected to apply for the next time. You know, you have to know the reason and fix it. Then next time you can get in, right? So data, for him to ask this one, request was rejected, right? Of course. Request for preliminary ruling for the it's a bank, and this all information is rejected. So here, the concept of personal data, scope of a right to access, and data subject. So whether as a foreigner, if I ask question and ask for the copy of the application and the processing documents to the immigration office, such as INS in US, this case is EU, apply for the immigration office in EU, do they have to provide the full copy of the process, like this stick a copy and send it to your address nicely? So that is the question. Here is the Charter of Fundamental of the European Union. It says, yeah, there is a certain right, data relating to the document preparatory to the decision. There is a right, okay. So why this data protection is there is to give trust. If if there is no process revealing the information to any authority, even I did wrong, then I will not do my best. So trustworthiness is important. However, it does not meet full disclosure of legal analysis. Or so original paper does not have to be provided fully. What they have done is they just text the message saying that your request has been rejected. Please apply next time. So notice by summary through phone text message is okay, and they don't have to give a full copy of original document to back to the person. So that is basically what the judgment said, right? Okay. So considering or question number 1, 2, 3, 4, the scope of personal information is quite wider, right? Became wider and wider, saying that any information, but maybe the analysis itself and maybe some information that is not for personal use, such as a security purpose, immigration process purpose, analysis is not part of personal information. What is personal information here is IP address, location information, cookies, DNA information, biological information, and also CCTV information is also personal information, right? Okay. So let me give you the example. Not this one. I just think about the CCTV question. Uh, there is a person in EU. Actually, there was a case, and somehow his house got broken couple of times. Maybe the window was broken and there is like calligraphy on the wall and there's a bad word written on the wall. So he put the CCTV not only facing the recording the spot of the the door, also included the spot for the road, which is a public spot. And the someone outside in the neighbor requested him to uh, to take the CCTV away because the person's private life is revealed through this CCTV. The system of a CCTV is actually not uh, not sorry, not completely rebuilt. Once the hardware is full, then image of the CCTV got deleted automatically, and then next image comes over to the uh, previous recording, videotaping. But the result judgment of this case is that since CCTV is facing uh, the road, which is not his personal space, he has to he has to take this CCTV away. So this can be the example of a personal space. So when you want to have your CCTV on, CCTV only apply to your private zone, not others. Others also have their own private space. So that is important also. Question number 5 here. This is a very important case. It was a really big case in EU in 2010, and Spanish citizens filed a complaint against the Spanish newspaper with the National Data Protection Agency, as well as Google Spain and Google Incorporation. Whoa, big case, right? And who do you think won? File the complaint. I didn't say anything else. This is Google laws. So that is why this case became big. Okay. Argument is auction notice of his repossessed home. That means that he got bankrupt and he lost his house. That is a very sad story. But again, this repossessed home news, there's an auction site and his house was on the face, on that page, open, this house is for the auction. And he doesn't want this information to be revealed later on once the auction is over, right? And after a number of years passing, to be exact, 6 years, and still the Google reveals the information this house is auctioned. Right? So, on the Google search result infringed his private right, privacy right. So that is the conclusion given by the ruling. 2014 is the ruling date. And even if the physical server of the company processing data is located outside of Europe, because the Google said server is not outside is outside of Europe, this private information directive does not apply. Yay! But EU rule apply to search engine operator if they have a branch of subsidiary in a member state. So this is many regulations they want to have hooking, you know, any linking to the server provider, also the service provider, they want to have this regulation to be kept properly. They want to have a link. So if the server, even if the server is outside, the branch was there. So they have to keep the regulation. The search engines are controller over personal data, and Google can therefore not escape its responsibility. See, we share the information of a data controller, right? Who is controller? Search engine, which is Google, which is Facebook, which is maybe in Korea, the green neighbor, also the Daum in Korea, they are also the controller and they are responsible according to the GDPR. Okay, so individuals have a right under certain conditions to ask search engine to remove links with the personal information about them. This applies where the information is inaccurate, inadequate, irrelevant, excessive for the purpose of data processing. So after 6 years of auction, you don't want that to be revealed again. So when you ask, they have to respond it correctly because they didn't respond it in accurate time. This went to the court and court ruled that Google lost. So now you have to delete his link. That is, and those times he spent so many time suffering because of the link, he got compensation. Okay, so this is something that you can get from your personal information, right? So, but there are two things. Clear statement by the court is the right to be forgotten. It's not absolute. Uh, Google can have a link, but there is a time limit. But there is an accuracy limit. So, but not will always need to be balanced against so that the two right has to be balanced against other fundamental rights such as freedom of expression and freedom of media. So the Google and the Facebook, for example, Apple and or other search engines, they have a right to express, right to media, media, but at the same time, people individually have a right to privacy, so they're keeping the balance depending on the case. So there's no absolute answer. There is a tendency of the case. Here, a case by case assessment is needed. That means you have to know as many cases as possible, right? What is personal data? What is profiling? What is balance information, balanced freedom of media, balanced freedom of privacy, right? So
I,
having many information is very
I,
important.
I'm sorry, Prof.
Yeah.
Uh, the time is just 5 minutes again.
Okay.
Yes.
So I'll be finished in 5 minutes.
Yeah.
Okay. Uh, here, this can go in real life of us. Data protection default at this moment, very moment, you'll be using your cell phone, right? So check whether you opt in or opt out. Anything that is already consented, you have to check whether that is important. Uh, is that site is too important for me, so I have to opt out, and maybe something that you have to have ask them your information be deleted as soon as possible. Okay. Uh, Next question. So these are the typical places you can ask for delete of your information. Telemarketing, promotional email, video surveillance. These are the most complaints of EU. So do you. Once the Indonesia is enacted this law, you may complain. You can make a complaint. You can get the compensation and no longer they will use your information. Okay. Issue of a fine. There are cases in EU. EU is collecting so many monies from the companies for violating GDPR, and this is a part of a tax, I think. So companies now have to be cautious of how they are doing their business in EU, right? Okay, this is also important. But here, in case there are twists here, question number 6. The Microsoft of Ireland case, this is a kind of different from EU. EU and US is basically different concept of right to privacy. So US basically don't touch them very much. They want to have freedom as much as possible, but EU like to control many things. So there are different two things. But then again, this Microsoft Ireland case made a new law of a Cloud Act, that is clarifying lawful overseas use of data act. So Microsoft for here for the information uh, for the federal government requested Microsoft to give email contents relating to the drug trafficking with the warrant. But then again, Microsoft denied it. However, after passing this Cloud Act, what happened is Microsoft had to submit the email containing all the information, private information of their, back and forth. So this Cloud Act become like a GDPR, yeah. So you have to consider the world we are living in. Right to privacy is becoming very important, but at the same time, having forced regulation is very important. So to make your company grow, you have to have IT gadget capacity building. But the limit is personal personal information protection is should be kept, right? Unless that happens, your company cannot grow bigger than now. Here, Dutch surgeon, she had the practice negligence, and so the woman had a problem after the patient got died. However, this she is back to work, but still the Google search, she is on the list of unofficial blacklist uh, surgeon. So many people checking her name, saying that she had made bad malpractice, so they don't want to have her as a doctor. That she sued the Google search engine, asked for the link to be deleted, and the final answer is yes, that has to be deleted because change of the condition. So every country had to have adequacy decision to have uh, connection to the EU. What about Indonesia? Indonesia is a personal data protection law, PDP draft law. Is now on the process. The House of Representatives plan to conclude the deliberation on the bill when? November. So you will see this law soon again in Indonesia. And finally, let me just finish this with the COVID-19 and personal information in Korea. There are so many personal information revealed in Korea by checking, revealing your information, such as here. Let me just show you the collection here. Here, only this one. Here, this is a scene in Korea when you go to the market. This is a bakery, and you have to write down your names here using these gloves, plastic gloves, checking the time, and also the sanitizer. This is the one set that you are using collecting information of you when and where you've been, right? And we have discussed many things about this personal information revealed too much in during the COVID pandemic. But there is a law called this, and here for the purpose of public safety, such as public health, in case of emergency, temporary process of personal information is allowed. So since there is a law allowing to collect the personal information in limited time, then there's no way we should block the process of having this one. So, and the border check also, there are so much checking, check, second paper check, and only dedicated taxi you can take and go to the hotel directly, and you receive thermometer, trash bag, food, psychological care for personal to be safe while you're in Korea. So although there is a dispute regarding personal information revealed in during the time of COVID-19, many people allow them to have uh, their information to be given. Also, I like to say this is final thing is digital resilience. What is digital resilience? While COVID-19 is that many people who doesn't have a digital gadget has been affected by the COVID-19 and they lost jobs. So here for how the Korea is competing and blocking the infection of the COVID is through the digital gadget. So having this situation, this digital gadget help student who is in low income children, they are given free internet, free gadget like a tab, iPad to have education. Otherwise, without having digital resilience, uh, COVID-19 may affect so many children in Korea. So having digital resilience is also important to protect the personal life, also the personal improvement during the pandemic. Yes. So there are two sides of the digital protection and also the having a non-discriminatory status as a result of a pandemic. Okay, so this is my presentation. Thank you. And if you have any questions, personally, you can write me an email. Thank you.
Thank you for the detailed lecture, Professor Hyun Park. To all participants, is there any question, please? Any question? Okay, Professor Hyun Park, this is this question from Agna Zahra. Uh, It is such an honor for me to talk to you today. My name is Agnazara. I'd like to ask about the personal data. As we know, our personal data is being saved by both the third party, such as Facebook, Google, etc., and the government, such as our ID number, our address. My question is, which one is safer if we want to save our personal data, the government or third party? Thank you.
Okay. Usually, thank you for listening the presentation well and ask question back. Those who can ask question means that the she and he heard the presentation sincerely. Thank you for doing that. And the question is, so giving information to the authority or the government or the third party is which one is safer? If that is question, having third party handling the information is also considered according to the definition of GDPR. I think that will be also under the definition of Indonesian GDPR. Is called the controller and also the processor. The controller is one who has a control of all the data. So government, if the government is giving third party a delegate of the right to handle all the information, then third party is a processor. As a processor, third party is liable for doing data protection according to this principle. So equally, uh, it is okay to give information to third party if it is handled by the government, because they are also under the name of the data processor. So they are both okay, but you have to make sure that if the government is requesting your information, that is okay. But the company is asking for information, you have to be very careful. These days in Korea, even in Korea, there are many spam mails and spam sites. It looks like a neighbor, but it is not. And they give you the link, which is fake neighbor, fake Facebook. So the link you get is not the correct HTTP. So you have to always check the link you are receiving is having the correct and official website address as it is they use it in Facebook or Google. Otherwise, you get the fake information, giving the money, sending the money. So those things happen in Korea a lot. Found out that those links are from abroad. Yeah. So information given to authority and third party is both equally okay, uh, but those that has to be given explicitly to you.
O-
Okay,
Okay.
thank you for the answer.
Uh, okay, Akna Zahra, any question more? Enough? Okay, enough. Thank you, Professor. This is the other question for my colleagues, lecturer of Faculty of Law, Diponegoro University. This is from Mrs. Industry Astuti, SIM Home. The question is how to formulate a policy for cybercrime with all of its unique coins, domains that are difficult to trace, the consequence that, that extend to the motivation that might differ from crime in the real world. Yes, this is in the chat zone. Okay, Prof.
So the question is whether doing the crime in the cyber and the real life is the same data crime. If that is question, having fine, this is this is not a criminal penalty. The GDPR is for the penalty given to the company for infringing the private right of privacy. So this is different from criminal penalty. Once you have a criminal part of action committed to you, then you may pursue separate action of a criminal process. Uh, this privacy protection is for basically for the compensation of the civil.
Okay, okay, thank you, Prof. The other question from lecturer of Faculty of Law Undip. The name is Diasta Manggita Ramadan SILLM. Good afternoon, Professor. I have a question regarding the personal data transaction. Here in Indonesia, we have the practice of personal data transaction. By transaction means there are seller who sell the personal data and the buyer who want to pay some amount of money to buy personal data.
Hafid, I cannot hear you.
Sorry, Professor. Maybe he have trouble in his connection. I will
I
continue with the question. Um, I have a question regarding the personal data transaction. Here in Indonesia, we have the practice of personal data transaction. By transaction means there are seller and buyer who want to transaction the data. How about your opinion regarding this practice? And also regarding the international aspect, is there any possibility that this practice is happen across the border? Thank you, Professor.
yes. Here I went to the articles that the GDPR presented. Selling personal data according to the request of a person is okay. Here in Korea, uh, the insurance company is now willing to sell personal information to others, like third companies. And according to the law, it is okay unless, uh, as long as a private person, the person individually consented the selling of the personal information. For example, there are like if I enroll the uh, homepage of CJ or the neighbor. I also or Samsung. There are so much branches relating to the big companies. Actually, Samsung company is the relative of CJ, and CJ company is also relative neighbor. They're all family members. So they have a company relationship each other and also the family relationship in any way. So they try to sell many information as possible. So when you allow them to allow you to ticket, every time you see the consent, you will see many tick. And one is first party that this information is mandatory, and second there's an option. And if you have a tick option, then that is possible. But however, financial information for the purpose of banking purpose, then that is much stricter part. For example, uh, in you can only give consent to the bank online, not there are three kinds of banking systems, right? First thing is you go to the physical part of a bank. Second one is online banking, right? In meaning online banking is using PC, and third one is using cell phone. So three things are all different. So you have to give, and they have to receive your personal consent separate. So selling is allowed in Korea, and I think that is where our society will be heading. Uh, so if you haven't used any cell phone, your information is the maybe the highest bid or auction point of those seller and buyer. So if you know someone who never used the PC or never used the cell phone, that person's information will be very high in bid. So selling market is already open. If if I summarize my answer, selling and buying is already open.
Okay, enough, Prof.
Yes. Okay.
Okay, thank you for Professor. Thank you for wonderful lecture, Professor Pak Hyun. Let me deliver the brief comment for today's lecture. Thank you very much, Professor. This is the um, I will to resume.
Hafid?
Okay. I am sorry because it's my house is turned off lamp. I will wait for a minute. This Thank you for the wonderful lecture, Professor Hyun. Let me deliver the brief comment for today's lecture. Okay, I will to read the conclusion and resume this visiting lecture from Professor Hyun Park LLD. Written answers submitted by a candidate in a professional examination and examiner comment with respect to those answers included. Any comment made by an examiner with respect to those answers constitute personal data within the meaning of that provision. Since daily working is different from person to person, you can recognize individuals by checking who works at what time and who took the outbreak at what time. Therefore, record of working time is personal information. Profiling personal data from EU GDPR Article 4, Paragraph 4. Profiling means any form of automated processing of personal data consisting of the use of personal data to evaluate on certain personal aspect relating to a natural person, in particular to analyze or predict aspects concerning that natural person performance at work, economic situation, health, personal preference, interest, reliability, behavior, location, or movement. Data protection principle in the article 5, paragraph 1 and 2, this is lawfulness, fairness, and transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity, and confidentiality, and accountability. The scope of personal information, IP address, location information, cookies, DNA information, biological information. And then tweet, the content of the underlying newspaper affairs should not be changed in the name of data protection. How how about in Indonesia? Indonesia first ready to enact
Sebentar.
new law and the protection of personal data. And then in the COVID-19 and personal information in Korea about the body temperature check, question by paper application, download second paper, check self quarantine safety. Dedicated taxi only, direct bus to hotel, you receive thermometer, trust bag, food, psychological care. And then thank you very much for Professor Bakihun. This is a wonderful lecture, Professor. Okay, we all participants, we have reached the end of our session today. Thank you for all your participation. See you on the next visiting lecture program. I give the time back to the host. Thank you.
Thank you.
Thank you very much, Mr. Mujiono, Hafid Prasetyo, SMH, for moderating the discussion, and thank you, Professor Ji-Hoon Park, for the wonderful presentation regarding personal data. Ladies and gentlemen, we have finally come to the end of our session. It has been a great and wonderful morning with all of you who have participated, and yeah, thank you for participating. I hope this is the beginning of the conversation and not the end. Thank you for all of you for being here today and for your great participation.
Thank
Thank you,
you.
Professor.
Thank
Thank
you.
you. Thank you,
Good to
Professor
see you
Park.
again.
We say see you later again in the other
Thank
moment.
you.
Thank you
Thank
for
you.
our participants.
Thank you.
For
So,
thank
goodbye.
you. We are warm grateful from other professor in Yongsan University, Professor Prof. Park Yung Chung, Prof. Kim Jong Tae, Professor Tan Chong Sik, and others.
Sure,
See
see
you.
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 See you in Korea then.
Yeah, after my this pandemic finish, I will to go. I will go to Korea. Keep healthy. Take care. See you later again.
Yeah, you should see Korean.
Yes.
Bye.
Bye, Prof. Bye bye. Thank you very much. Okay, kita keluar.